Uh, my name is Andrew Chen. I am the staff attorney for homelessness and housing at CCWRO. It looks like somebody just came in. So, Dave, maybe we can restart the recording once. um, looks like somebody is joining. Yes. Okay. Yeah. Yeah. There's an LSLA team. Okay. Great. So, hi, you guys. You didn't miss anything. We're just getting started. I was saying my name is Andrew Chen. I'm the staff attorney for homelessness and housing here at CCWRO. And today we are going to talk about eviction defense basics for benefits advocates. As I'm sure a lot of you have seen in your caseloads, housing and benefits issues walk hand in hand. They're completely intertwined. Oftentimes they support or hurt one another. And so today I basically wanted to give you all a brief overview of what the eviction defense process looks like, how, what are the major deadlines, and the best ways that folks who aren't directly representing tenants in eviction defense can um, support clients that are going through that process. Um, so, yeah, do you have any questions before we get started? You can put something in the chat or unmute. Okay, well, we'll get started. So yeah, my name is Andrew Chen. I have been a legal aid attorney for 7 years now. I have done housing and homelessness work the whole time. I was a legal aid attorney at Public Counsel, and I ran a legal clinic for unhoused transition-aged youth at Safe Place for Youth in Venice, Los Angeles. And then I moved to Bet Sedek and kept doing that work, and then also defended low income tenants in eviction defense proceedings, which is where I got the experience to give you all this presentation today. Um, yeah, so why learn eviction defense? As we said, benefits are increasingly tied to housing, and housing insecurity benefits can directly affect benefit eligibility. And benefit eligibility maintenance can often directly affect housing. If you don't get your cash aid on time, that could prevent you from making rent or prevent you from meeting other expenses that will keep you housed. And I think the other important thing to know is that the eviction defense timeline is highly accelerated. The state of California, and I think every state, has basically made the policy decision that the disposition of real property is really important, and needs to be resolved quickly. So when you see a client that has an eviction issue, it's the whole thing is going to move very quickly, and so I think it's useful for benefits advocates and other folks to be on their toes when they have a client who's facing an eviction, because things move really fast. So this is an overview, a bare bones overview of the eviction process. The whole thing, like I said, is very accelerated. It often takes less than a month. The first thing that'll happen is the landlord will serve the tenant a notice to quit. We'll go over the various kinds of notices that there are. So 3 day notice, a 60-day notice, and various COVID restrictions that still may be in place. At that point, the tenant will have an opportunity to cure the violation. They'll have to, cease the nuisance or, pay back the rent that they owe. And if they fulfill those conditions, then oftentimes an eviction isn't filed. But if they fail to complete that process to a level that the landlord deems satisfactory, the landlord will then move to B, the complaint stage. And that's the actual lawsuit. That's where, papers are served on the tenant, and the tenant has to file, an answer, and this month-long process that we're talking about, this accelerated process, gets kicked off. Yeah, so there is a complaint, an answer, and sometimes there is some bare bones discovery, but it all moves really quickly, and you don't often have time to, take depositions. Oftentimes you're just sending interrogatories back and forth. Maybe hopefully doing some inspection of the premises, especially if your tenant has defenses related to habitability or other conditions. But yeah, so it's often quite bare bones. And then if the case doesn't settle, it goes to trial, and then obviously, there's judgment. So this is the whole process we're going to be talking about today. And yeah, if anybody has any questions, feel free to chime in and chat. I'm not sure if the meeting settings make it so you can unmute yourself or not, but feel free to jump in. This is going to be pretty informal as far as presentation process goes. So the first step, notice to quit. So the amount of notice that the landlord has to give the tenant depends on the kind of lease or tenancy. So typically, if it's a month-to-month notice, they have to give them a 3-day notice. And then if it's an annual or a longer lease, they have to give 60 days. Sometimes there are different restrictions for this. For example, in Section 8 and other subsidized housing, you can have a timeline that's 90 days or more. And in some jurisdictions, they've adopted what are called good cause evictions. I believe when I left LA, they were kicking around this idea, and I'm not sure if it ended up passing or not. There were a couple bills to make the entire state adopt this, and I don't think that those passed, as far as I know. But basically, what a good cause eviction law means is that landlords cannot arbitrarily decide to evict a tenant. So, for example, a tenant who's under a normal month-to-month tenancy, could essentially be served a 3-day notice to be out by the following month at any given time for most reasons. For example, if the landlord desires to rent it to somebody else, or they decide that they are going to, move into it themselves or move a relative in. If it's a month-to-month tenancy, oftentimes that just needs a 3-day notice. But in good cause eviction jurisdictions, you often cannot evict tenants at all for those reasons. It has to be for something such as non-payment of rent or a nuisance, or the breaking of some criminal law, or other concrete violations of the lease terms. One important thing to note with lockouts. I don't know if anybody's ever seen this, but oftentimes, clients will come in and they'll say, well, the landlord, I wasn't able to pay rent last month, so the landlord just changed the locks. In California, you aren't allowed to do that. You aren't allowed to lock out a tenant or change the locks before there's been a writ of possession issued against the tenant, and the tenant has been formally evicted by legal process. You can oftentimes use illegal lockouts as defenses to prove, bad behavior on the landlord's part. But yeah, the important thing to know there is that if your client does find themselves with their belongings thrown onto the sidewalk and their key no longer working, that is illegal and you can't do that. We're also going to go over some COVID restrictions in the next couple of slides. Most of these have gone away by now, but some of them may still remain depending on what jurisdiction you're in. And it's important to note that when the notice is served on the tenant, it can be served one of 3 ways. It can either be personal service, it can be substitute service to another adult or other qualified representative that's at the address. This can include other tenants. So if there is a building, if they have roommates but they're on separate leases, or you have sort of a duplex condo kind of situation, service can be served on a person as long as they're at the same post address. And they can also do what they call nail and mail or post and mail, where they attach a copy of the notice to the door and then also mail a copy. And these service requirements also apply to the complaint, which we'll talk about in a second here. So COVID-19 protections. During COVID, from March 2020 to March 2022, there was a statewide program in place to assist tenants with back rent. It was structured in such a way that allowed landlords to apply directly for the relief. Tenants could apply, but landlords were eligible for less compensation than if they applied directly to the state. So that was the state's incentive to get landlords to apply. However, this program expired in March 2022. Some cities and counties still have protections in place. I don't know where everybody's tuning in from today, But you should, check your local jurisdictions and see that. One really important note, though, is that if your client applied for rent relief before March 2022 and is waiting to hear if they're eligible and receive an eviction for that rent in the meantime, so that is for the rent that is was due to COVID-19, that was due to COVID-19 restrictions sometime between March 2020 and March 2022. They can use their application for rent relief as an affirmative defense to the eviction. Basically, the best way to think about this is that if the landlord is trying to evict a tenant for money specifically that is due for uh, during COVID for COVID related hardships, and they've applied for rent relief and they just haven't heard back from the state, they can't be evicted for owing that money on that basis. However, there are oftentimes a lot of accounting tricks that landlords use to sort of try to get around this. Where they'll waive service certain months and then try to charge more on additional months. So you need to be vigilant for those kinds of tricks as well. Sample notice to quit. So these are basically like the common forms that you can either print off of various landlord plaintiffs bar websites or off of the state bar website, not the state bar website, these courts.ca.gov. So as you can see from left to right, we have a 3-day notice to pay rent or quit. As you can see, there is a space to name the tenants and occupants in possession to show how much rent is owed from what periods of time. Notably, you see that the money has to be paid to a specific person and a specific agent at a specific address, and they have to receive the payment personally blank days between the hours of blank and blank. It's really important that every blank on this form needs to be filled out concretely. When I was doing eviction defense, I won a lot of cases really easily just because the landlords didn't take the time to, uh, uh, fill out, for example, um, the address or what time they should drop the check off. And those are affirmative defenses. Like you can serve a motion to quash, as we'll talk about in a second, because for ineffective notice on that basis. And oftentimes, the extra time that will buy you will give you time to negotiate a settlement or get CalWorks homeless assistance. And it's just they'll still owe the money at the end of the day. It doesn't. They can still refile. It doesn't dismiss the action with prejudice, but it is a really good thing to look out for because oftentimes landlords, especially like smaller landlords, don't want to go through the cost and expense of rehiring an attorney and refiling. Um, so in the alternative, you can see that they are required to vacate and deliver the premises to a specific agent, and then it has to be dated and signed. Next on the notice to cure or quit, this is this image in the middle. Similar things. You can see that they have to cite exactly which provision in the lease was violated. They can't just cite generalities like noise or trash or something like that. They have to name specifically in the lease where those things are mentioned. And that's in part why getting a copy of the lease if you're working with a tenant who's facing eviction is really important because it'll help you give them better advice as to how they can proceed from there. And yeah, similar thing with the last slide, which is a 3-day notice to quit for nuisance or creating waste or illegal activity. As you can see, they need to provide really specific instances, like dates and the type of behavior. So yeah, the complaint. So after the notice, typically if the violation isn't cured, the landlord then moves to file an actual court case and to file a complaint. It lays out the allegations against the tenant. That, like we've been saying, it can be non-payment of rent, nuisance, overstaying your lease term, or no fault evictions also. So this is for things like moving family back into in-law units and that sort of thing. Um, and there are a lot of defenses to defective complaints. Where, like I said, this is just a basic overview, so we're just going to cover the most common ones today. For example, the notice has to be attached to the complaint. A really common thing where the complaint gets served on the client, but there isn't a copy of the notice attached. That's ineffective service, and you can, quash the entire action on that basis. Similar thing with the lease. The copy of the lease has to be attached. Um, a case not based on failure to pay rent. Yeah, this is an interesting thing where occasionally you'll have landlords that'll use the paperwork for a failure to pay rent. But the actual underlying allegations of the complaint aren't about failure to pay rent. They'll be about various, personal problems that the people have with each other, or nuisance or noise or something like that. Um, Incorrect address, another surprising thing that people get wrong, and improper plaintiff as well. Oftentimes, especially with housing being as difficult to maintain as it is right now, you people have really complicated housing and living situations, and sometimes people are named on documents. Um, that that people are have the wrong name on the complaint. Or they'll name family members, or significant others or something like that, and you can also quash an action on that ground as well. This is a sample summons and complaint. Um, uh, as you can see, like, this is just a judicial counsel form. It's used in English and Spanish. Uh, there has been, there is, a language access is not like as well a developed area as far as defenses to eviction go, but it's definitely something that's worth looking at. As you can see here, like, it has the name and address of the court, the name and address of plaintiff's counsel, and on the second page across from that, uh, you can see in the jurisdiction box, for example, it says, action is a limited civil case, and it, does not exceed $10,000. Um, this is surprisingly is something also that you can get complaints dismissed on as well. And it's just really important here in summary to just go through each line and make sure that each line is accurate and that it's filled out correctly. Because if one of them isn't filled out correctly, you can often, make the landlord refile on those grounds alone. Notably, this isn't the entire complaint. There are additional pages after this, but they're not really important to go over in detail right now. And the answer, so responding to the summons and complaint. Uh, One thing that I think is important and that um, folks don't often appreciate is that you can amend your answer. And you have sort of a one free bite at the apple to amend your answer. And so, what's really important is just getting the answer in within the window of responding to the complaint, which is 7 business days. Um, and and so you just want to raise basically every possible defense that you can. If there's a habitability problem, even if you're not sure, whether it rises to the level of, an affirmative defense or not, like, state it. If there are problems with discrimination or harassment from the landlord's part, even if you don't have specific evidence of that yet, state it. And the reason you want to do that is that you lose the opportunity, if you don't state it in the answer, to raise it either at trial or on appeal. And so it's sort of a shotgun approach. Is it, the most neat and tidy lawyering ever? No. But it's really important in this case just to make sure that your tenant and your client have all the possible defenses that they can have. Um, then, in addition to substantively answering, there is also some ways to try and dismiss the complaint. The first thing is demur, that's failure to state a claim. If they are, like I was saying before, if they're filing for non-payment of rent and the complaint doesn't state anything about rent, you can file a demur. Um, Improper service, you can file a motion to quash. If the service was mailed but not posted, or posted but not mailed, or given to an improper party, given to a neighbor, for example, as opposed to the person that actually lives there. You can quash the whole complaint right then and there. And then there's something called a prejudgment claim of right to possession, which is long and complicated. I never had to do this personally myself. So I, am not an expert on this particular motion specifically, but it's intended for tenants who are in possession but not named. So, for example, if you have two roommates who share a lease, but only one of them is violating the law or causing a nuisance or something like that, you can file a prejudgment claim of right to possession if you're representing the tenant that is not subject, that was not a part of that claim, even though they were who were in there but not named. Oftentimes, landlords will get around this by just saying, and all other tenants in possession, which for some reason works. But I like to fight complaints on those grounds, um, and I think it's worth trying to do. Yeah, so a sample answer we have coming up here. Most courts have sample forums. There's a judicial council forum for this. Um, I used it in practice. Like, there's really no need to reinvent the wheel here. When you're attaching uh, evidence and making arguments and stuff, you will attach your own writing in that regard. But as far as the actual like filing goes, there's no reason not to use the judicial council forum. Let's see. Yeah, many courts also have self-help clinics where legal aid attorneys or volunteers will help pro se tenants fill out paperwork. These are hit and miss in my experience. There's a lot of people in line. No shade to our really valuable pro bono volunteers, but oftentimes the self-help clinics are staffed by um, law firm volunteers or pro bono volunteers, and they often don't have as much experience representing tenants directly. And so sometimes that can lead to issues with the paperwork. Uh, Importantly, counties are starting to implement right to counsel laws for unlawful detainer tenants. This works similarly to how it does for public defenders and right to counsel in criminal matters, where if you fall into a specific income bracket, you have a right to an attorney. I know Los Angeles has this now, and they've been implementing that. Um, Again, answers can be amended. The key is to just make sure that it's submitted on time, and assert all possible defenses, or you lose the right to raise the issue later. Here's an example of the first page of the sample answer. This is the judicial counsel form. One thing that can kind of be obnoxious is filling out like section 2B1 here, where you have to admits that all of the statements of the complaint are true, except, and then you need to name the ones, and it does give you a text box here. Text box here is just sort of a blank form, and sometimes when people fill out these themselves before they find representation, it can be really messy. So just make sure you check that space and make sure it's legible, and also obviously matches up with the complaint. Don't take that for granted. As you can see, there's affirmative defenses checked here. On below, what you don't see here is there's a whole section on the back that says other affirmative defenses, and then it sort of leaves you a large text box. What we usually did in practice there was to simply just attach. We would just see attachment A, B, C, and we would just attach our own writing there, because the judicial counsel forum often does not have enough space for you to adequately explain what the defenses are and sort of on what grounds you're making them. Common tenant defenses. We're going to spend, I think, most of our time today on this like last quarter of the presentation, just because when you are a benefits advocate who doesn't necessarily represent eviction clients in court, what I found my most valuable role to do when I wasn't representing tenants was to sort of act as a secondary attorney. Obviously, you're not giving them advice on their landlord-tenant matter, but when it comes to gathering evidence for them, that can be really, really valuable. Specifically if you're looking at things like habitability, if you've had to um, litigate issues related to benefits in the state of housing in the past. If somebody has had issues with their housing voucher, and their Section 8, and the inspection came back and said, oh, the beneficiary did not do X, Y, or Z. They need to do X, Y, or Z, in order to keep their housing, and you have documentation about that. If there's a pest control problem, for example, that's actually the landlord's fault and not the tenant's fault. That could be really valuable paperwork for the tenant to have in their eviction process. Um, and also, things. So habitability is probably the most common defense that's asserted. A lot of folks who are low income and are living in housing, there are a ton of problems with the housing that they're living in. Um, I don't know if anybody tuning in here primarily lives in LA, but essentially, uh, there are a few buildings in LA that have had literally thousands of violations, cited violations, where the Department of Housing and the Department of Health has gone in and told them to fix these things. And yet, months later, only a handful of them have been fixed, or they say they're fixed, but they're not actually, fixed to an appropriate standard. Um, and so habitability is often like a really strong defense and a really good um, way to keep your client housed. There's also, I'm not going to go into all of them today, but there's certain things that are absolute. For example, lack of heat. Lack of heat by itself, per se, makes a dwelling uninhabitable. So there's a long list of conditions where it's not that they need to be so decrepit that it's sort of it looks uninhabitable. It's just those conditions existing makes the dwelling per se uninhabitable. Retaliatory eviction, another really common thing. Oftentimes tenants will, ask their landlord to fix problems. The water doesn't work, or the heat doesn't work, or the air conditioning doesn't work, or other fixtures aren't functional. And after a certain amount of time, maybe the relationship deteriorates. Maybe the landlord refuses to fix these things, and they just sort of get tired of the tenant, and so they decided to file for eviction and sort of make up grounds. And we saw this all the time, and so we often asserted retaliatory eviction as a defense. It can be difficult to prove, specifically because tenants are regular people just like us. They're not um, recording every single day of their lives. They may not have concrete evidence of what the landlord did or didn't do. However, I've found in my practice that has gotten better over time, strictly because I think the promulgation of video on social media, and I think people understand now that recording a conversation is good in order to protect themselves. Importantly, California is a two-way recording state. You need to have permission from both parties. But if we're just talking about um, pre-litigation negotiation or something like that, you can often use these things not to assert facts, but simply to gather evidence and craft your arguments. Estoppel, often used for conduct where a landlord will okay behavior that's not allowed by a lease and then revoke that permission later. So the classic example of this is, so and so has lived in their apartment for 15 years, and in all that time, and they have a 12-year-old cat, that they got, the third year that they lived there, and their lease doesn't say that they can have pets. Maybe the lease specifically says no pets. But they talked to the landlord when it happened, and the landlord verbally said, yeah, okay, well, that's fine. It seems like a sweet cat. Like, go ahead and keep it. And then, for the following 12 years after that, they have paid rent, and the landlord has accepted the rent and continued to renew the lease with the implicit understanding that they have a pet, and that's okay, even though it's states differently on the lease. Oftentimes, landlords will do this because they're trying to. They may be unable to evict the tenant otherwise, and they're trying to raise the rent to market rate, for example. Um, uh, but yeah, so there's a lot of equity equity that comes in eviction defense and unlawful detainer. Here you could basically show reliance on the tenant's part, saying, hey, for more than a decade, this person has paid rent under this specific assumption, and they've relied on that, and they're harmed by the landlord's going back on that reliance. One other really important defense to note is waiver. If the landlord accepts rent, they waive the complaint. So I saw landlords sometimes who would accept, partial payments, or or accept the full rent and then still try to go through with the eviction, and they can't do that. The complaint is based on the non-payment of rent. If they accept the rent, they are reinstating the contract implicitly, and so they're not allowed to go forward with the eviction. Violation of civil rights. This is very important. Tenants in California are covered by all of the areas of non-discrimination law that California residents typically are. So that's race, color, sex, religion, national origin, marital status, sexual orientation, number of children, occupation, physical or mental disability, or because the tenant is receiving public assistance. I want to specifically note the number of children and the receiving public assistance portion of that, as well as the disability portion of that. Number of children. I had a specific case where a family was being evicted from a home because the landlord was saying that the children were too loud. And basically, there's a whole other area of law by itself where it's basically that if children being children and playing in common areas is not per se a nuisance. But number of children can also be a part of that. Obviously, the more kids you have, the busier it is, and the louder it gets. So if you can show that the landlord's reason for filing the complaint is based on an effect that comes from the number of children, that is a civil rights violation. And also with receiving public assistance, that includes receiving housing vouchers. They're increasingly, although California law states that landlords cannot refuse to take a tenant on because they receive a voucher, that's really difficult to enforce, especially with housing being in high demand as it is. The landlords can basically, deny a whole bunch of tenants for any reason. It's really difficult to prove. But it is important to note, and if your client does have some kind of housing voucher from the state or federal government, it's something I would keep track of as a benefits advocate. I would just check in on them, ask how their relationship with their landlord is. If there's documentation showing that the landlord knows that the person is receiving public assistance. Those are all just good things to keep track of, because this is a problem that we're seeing more and more. Is that tenants are being evicted or are being denied applications because of their status of receiving a voucher, and it's difficult to prove. So I think just as a community, we need to do a better job of gathering evidence related to that, so we can really put those laws to use. There are a lot other defenses as well. I just decided to list the most common ones that are laid out here. There are COVID-19 defenses, for example. So the vast majority of unlawful detainer eviction cases settle out. I think probably more than 90% of my cases did, which was kind of a bummer for me, honestly, because I wanted to take these folks to court and, rake them over the coals for all the stuff that they weren't doing. But obviously, as attorneys and advocates, our responsibility is to do what's best for the client. And oftentimes, thankfully, we were able to negotiate through benefits advocacy, through CalWorks HA or other sources of funding. We were able to pay the back rent and keep the client housed. Because also the vast majority of unlawful detainer cases are failure to pay rent or non-payment of rent. I also think, upwards of 80 or 90% of my cases were a failure to pay rent. So there's typically two kinds of agreements that are most common, two types of settlement agreements that are most common. The first one is obviously, you pay the rent or you come to some kind of payment plan and the tenant stays. The second is a move-out agreement with a sealed record. So basically, this basically takes the eviction process and moves it out of the court enforcing a writ of possession against the tenant, and it's basically a contract that says, okay, like I such and such tenant name agrees to move out of such and such address and relinquish possession of such and such landlord by X time. And in return, what is common and standard, like bog standard, the bare minimum is that there's a sealed record with that. And the reason we do that is that so that the record of the eviction proceeding doesn't show up on a background check. Even just having an eviction filed against you, um, if it is allowed to be searchable and discoverable in background checks, can really damage a tenant's ability to rent in the future, because the landlord will just take a look at that record and say, oh, like this person had an eviction filed against them, and they won't even investigate to see whether it was justified or not, and they'll just deny that application and take one of the other 200 people that are applying for that apartment. So getting a sealed record is really important in that regard. And yeah, as I've been saying, benefits enrollment can be really helpful here. CalWorks HA is emergency rent help, making sure somebody maintains their SNAP or their SSI or their GR or GA, just frees up income that can go towards keeping someone housed. Um, Judgment. So if you go to trial, obviously there are two outcomes. If the tenant wins, they are not required to move out, but they may still owe the rent. It depends on the circumstances. Sometimes the trial decision will say, for because of these habitability conditions, the rent that the landlord is demanding for XYZ is waived or reduced to a lower amount, or something like that. Um, However, unfortunately, the economic reality for a lot of our clients is that the rent is just too high, and our clients are not paid enough or have other intervening expenses, and so the landlord can simply refile the next time rent is missed. Also, a lot of belligerent landlords will find or invent new grounds and refile. So unfortunately, even if you win at trial, it is oftentimes a temporary reprieve for the tenant. Sometimes that's not the case. Sometimes it's just a simple misunderstanding where everybody clears up and the relationship is salvaged. But oftentimes, eviction happens as the result of somebody losing a job or having an unexpected medical expense, such that they can, or they have, debt such that they are unable to make the rent. And um, simply beating the eviction in court doesn't solve that larger structural problem. Obviously, the other result is if the landlord wins. If they do win, there is a step-by-step process that happens to return possession of the property to the landlord. First, the landlord will issue what's called a writ of possession. That's basically, giving landlord possession of the property back. That writ then has to be served on the tenant. All of the usual sort of caveats apply there. Uh, Law enforcement, typically the sheriff's department, will come to the door and post a 5-day notice to vacate. And that's a hard deadline. Unfortunately, it is very difficult to get that deadline extended. You can submit a motion to stay execution of judgment, but in my experience, typically without really exigent circumstances, illness, hospitalization, um, something like that, death in the family, it's going to be really difficult to extend that. And they really do mean 5 days. The sheriffs will literally, unfortunately, take people's possessions and throw them out onto the lawn. Um, and yeah, and it's awful and miserable. So, um, yeah, so going on to the best ways I think that benefits advocates can help. Like I've been saying, being just aware of how fast UD or eviction cases that can move is really critical. Knowing what rental subsidy benefits clients are eligible for, whether that's CalWorks HA or some other kind of local program rent subsidy. Also establishing contact with the attorney that's representing them for their eviction matter. I think teamwork really does make the dream work on this sort of front. I used to do this kind of thing when I was representing youth, who had co-occurring criminal law cases where I would talk to the public defender and get letters of support and other kinds of documentation. And I just think this is something that more legal aid attorneys need to do in general is work together, even if they're, and you can do whatever agreements regarding client information confidentiality you need to, but I think establishing that team is really important because oftentimes a client's life experience is divided up against a whole lot of agencies, a whole lot of different agencies and lawyers and other individuals, and the more we talk to each other, the better. Also, directing pro se tenants to legal aid representation. Oftentimes, people will fall through the cracks, or they don't know that they are entitled to an attorney in eviction proceedings, or they may not have understood that. And because it's such a fast process, getting an attorney involved early to identify the affirmative defenses and get documentation is really important. And so benefits advocates can be a really useful conduit in that regard as well. And like I've been saying, it's sort of coexisting with the getting on one team with the eviction attorney, providing evidence of disability and other hardship. Oftentimes benefits advocates have access to paperwork and documentation that even the client may not have regular access to. If you have a client who's on SSI and you have literally, years of medical documentation providing evidence of their condition, and say the basis for the eviction case is something related to disability, like you have absolutely critical information. And so assuming that you have the client's informed consent to do so, I think providing that kind of documentation is really a good thing. And also just because honestly a lot of the plaintiffs bar, the landlords bar in this regard has really used to running over pro se tenants in court. They often are not used to practicing against real attorneys. They don't want to do that much work. They don't want to go through all the documentation you sent them, and so it can be a really good way to get a favorable settlement for your client in that way as well. Also, tracking conflicting deadlines. As we know, in the welfare to work world that we've been in since the 90s, there are all sorts of recertifications and reapplications and appointments that people need to go through. And oftentimes, when they're going through an eviction matter, they are incredibly stressed and have trouble tracking all of these conflicting guidelines. So, just making sure that you and your team, as benefits advocates, are really on top of, knowing when their CalFresh or GR or SSI appointments or recertification things are can be useful, not just to make sure that they keep those appointments, but also in terms of scheduling court dates. Where that day in court, if the attorney knows, like, hey, this person has an appointment at the Social Security office, a month from now, you can't schedule trial or or a settlement conference like on that day. Those are surprisingly important things to do. And another thing that isn't listed here as well is transportation. Um, as we know, especially in big cities like LA, in San Francisco and Sacramento, public transit is not always reliable. And so, if you have ways, whether that's bus tokens or, when I was at Safe Place for Youth, they actually had like an agreement with a rideshare app where their youth could get rides for appointments and various things, and then it was charged back to the organization. So that can also be a really useful way that benefits advocates and other people connected to grassroots, drop-in center services and other such things can help with eviction defense. Um, so yeah, so that's the whole presentation. We have about like 10 minutes left for questions or so. I think a couple people have dropped out, which is fine. So yeah, if anyone has any questions, feel free to put them in the chat. This is my contact information here. I'm happy to answer any questions you might have that are more detailed than I was able to cover in the presentation. So yeah, that's what they did. Thanks for coming, and yeah, I'll stick around for questions, but otherwise, hope to see you again next time. I'm planning on actually doing a uh, uh, yeah, so definitely has a question in the chat, but I'm planning on doing a presentation about care courts as well, in the spring, so look out for that. I'm excited to talk about that. So definitely ask if I can talk about some of the variations with subsidized housing. Definitely, do you mean in terms of like Like, what do you mean specifically in terms of the eviction process as it relates to that?
Can you hear me now?
Yeah, I can hear you.
Yeah, there's some odd wrinkles with subsidized housing
Hmm.
in terms of some rights to pre-hearings. Like in Section 8, you can actually ask for a pre-hearing and a hearing to actually help the person keep their voucher
Yeah,
and slow down an eviction,
yeah,
which can
totally.
be helpful.
Yeah, totally. And especially when it comes to like, Section 8 inspections and things like that, as there's additional layers of protection that tenants have in terms of hearing rights, to challenge findings, and that sort of thing. Sometimes landlords will try to jump the gun on that respect, and sometimes they'll try to bypass the housing authority entirely. So just, knowing that your client is on a Section 8 voucher, in my experience, the housing authority offices were hit or miss, but overall, like, more helpful than not. And especially if the landlord was trying to jump their authority, they really don't like that. So making sure to involve the housing authority directly when you know that when they're experiencing a UD, I think is useful. Some people will say you shouldn't do that because it can alert them to problems that might be on the premises that they didn't know about. I tend to think that, if the landlord is filing an eviction and they're not involving the housing authority, like, they need to know, because there's all sorts of procedural rights related, and the housing authority may even have, inspection information related to things that the landlord is complaining about that are not the tenant's fault, um, and you don't want your tenant to get evicted for something that the housing authority found was not the tenant's responsibility. Um, yeah, yeah,
Okay, and then there was one other thing I would
mhm,
just direct people to. The State of California Department of Consumer Affairs has a very useful tenants' rights and responsibilities website and booklet, which is useful to have and be
yeah,
familiar with because it can answer a lot of your questions if you're not used to doing housing,
yep.
and it can. I just give it to clients. Let me just put it that way.
Yeah, yeah, and there's a lot of really good treatises and law summaries that are normally very expensive books, but oftentimes people have in digital form one way or another. And so, like, reach out to me or reach out to your local agency that does like eviction defense work, because oftentimes they'll have really good um, like case books essentially for that kind of thing that are very helpful. Yeah, any other questions?
No, just thanks a lot, Andrew.
Yeah,
It's been really nice to see this
no,
vision of mine come to life. So
yeah, no, it was great. And thanks again, Daphne, for coming up with the idea, and thanks everybody for coming.
thank you.